All right. Good morning, everyone. Welcome to the meeting of the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. And Angela, could we start by taking the roll call, please?
Yes. Benola,
Present.
Bacon,
Here.
Bradley,
Here.
Brown, Shivers,
Here.
Fields,
Here.
Krieger,
Here.
Mark,
Here in darkness.
Mercado,
Here.
Munoz,
Here.
O'Reilly,
Here.
Poindexter,
Here.
and Starr. Thank you.
Okay, and next on the agenda is the public comment. So do we have any people present to give public comments? Could you check on that?
Yes, if anybody here would like to give a public comment, please use the raise hand function at this time to let us know. If you're participating by phone, you can virtually raise your hand by pressing the *9 keys. At this time, I will check if anybody has a public comment. And it does not look like we have any.
So the next on the agenda is the approval of the minutes from our last meeting. So if we could take a vote on the approval of the minutes.
Is there a motion to approve?
I
I'll
will
make
move.
a motion to, yeah.
Bill,
Or I'll
and
second Brandon.
Brandon, okay. Thank you. I will now take the vote to approve the minutes from the May meeting. Bacon,
Approve.
Brown, Bradley,
Approve.
Chivers,
Approve.
Krieger,
Approve.
Mark,
Approve.
Mercado,
Abstain.
Munoz,
Approve.
O'Reilly,
Approve.
Poindexter,
Approve.
Starr, and Benola.
Approved.
9 approve, 1 abstain, the motion carries.
Thank you. And I think we next have a staff report from Erica. Thanks, Erica.
Yes, thank you, Sarah. And I'm actually going to let Leah go ahead and kick us off on the staff report, if Leah, that works for you, and then I'll go into some more of the more administrative things.
Sure. Well, I asked Erica if I could hop on this morning, just really to express my thanks, the thanks of the board chair for all of your work on Rule 8.3. Hopefully you all saw that the court issued its order on that rule. And I think this has to be a record time for rulemaking for both State Bar and the Supreme Court. And I just really appreciate it. I know it was a really hard task and a very compressed timeline. I know it was difficult to reach kind of a consensus between both the COPRAC and staff on what to advance. And you saw that ultimately we advanced 2 proposals to the court, and they came out with yet a 3rd proposal. But I do want to share that at least initially, the feedback from Senator Umberg's office is very positive. We believe he will be withdrawing his sort of bill that had its own version of 8.3 in it, although I hear that he still wants to add something about attorneys reporting when other attorneys are participating in treasonous acts. So I think we may see that yet in our fee bill. But aside from that, we really avoided something that we didn't want, which was to have sort of a rule of professional conduct in statute and not authored by the court. So thank you very much. And thank you in advance. I know we've also given you a tight timeline to turn around rules on the use of AI. And really in both of these regards, we're asking COPRAC to help us ensure that we are staying sort of at the forefront of issues that are really important to the bar. Of course, we are the last state in the country to get on board with Rule 8.3. But given everything that happened with Girardi, that obviously wasn't tenable for us any longer, and you helped us move that very quickly. And now here we are with AI sort of rampant utilization without a lot of clear guidelines for lawyers. And so we're asking you to step into that space as well. So I appreciate it. And again, on behalf of myself and the board chair and the entire board, I just wanted to say thank you. And if anyone has any questions, happy to answer them, or comments. I'd love to hear it. Okay, well, that's
Thank you, Leah.
Thank
So,
you.
hearing and seeing none, I can go into the rest of the staff report if that works for you, Sarah. All right, so an administrative update relating to Bagley-Keene, just to make you aware. Currently, Government Code 11133 is allowing COPRAC and other state bodies to convene in the way we are today, meaning that it's a public meeting that is being conducted solely through remote means. Per the statute, this authority to do this in this way is going to sunset effective July 1st. There is a bill proposed to permanently retain the amendments that would allow us to continue to conduct meetings exclusively remotely. That's SB 544. However, with 7 days to go, it's not clear that the bill is going to be enacted prior to the sunset on July 1st. So just wanted to give you kind of a heads up on that. That could mean that our next meeting on July 28th will still be able to be conducted remotely, but in a manner that was kind of happening in the past, where you could be remote, but you'd have to be doing so from a location that was noticed. So the address is provided. The public has to be allowed to attend the meeting from your location, and that location has to be ADA accessible. So we'll be giving some more guidance on this, in July, once we're more certain on what's going to occur. If for some reason you don't have a location and cannot go to either the State Bar's SF or LA locations, we can possibly provide some space through like a WeWork or a day of office space that would work for. But just wanted to give you a heads up on that. And then I wanted to just give a brief update on public comment on the civility rules, and then also on the interim opinions that COPRAC currently has out for public comment. But I wanted to pause for a second here, and if you have any questions on the Bagley-Keene matter, I can address those now. All right, seeing and hearing none. So public comment on civility items. So as we've talked about quite a few times, this committee did work on the rules of professional conduct that are being proposed. That's proposed amendments to Rule 1.2, 8.4, and a new standalone Rule 8.4.2. So the public comment period on that is ending later today. So far, in review of the public comments, they're pretty similar to kind of what we saw in the first round. There's just less of them. So the majority are in agreement with the proposed changes, a few disagreements, of course. And that's also the same for the attorney oath that's proposed in Rule 9.7. So public comment on both of those, as well as some proposed MCLE rule changes, is set to end today. So staff will be evaluating those public comments and issuing its recommendations to the board in light of those public comments. On the interim opinions, so there's the two opinions that are currently out for public comment. That is lawyer as expert witness 20-0001 and succession planning 20-0002. So far, there's no comments on 20-0001, and we have only two comments on the succession planning opinion. One is a general opposition to that opinion, and the other is a brief agree if modified, so long as there's training and support on how to accomplish succession planning. So once we have some more substantive comments or more detailed comments, we'll certainly be distributing those to the working group members, and they'll also be posted to SharePoint for the entire committee to view if they would like.
Erica, when is the public comment period closed for the expert witness draft?
It's beginning of August. Don't hold me to the date.
I think it's on the date of our next meeting, August 18th.
Right, because I know LACBA's ethics committee is working on a comment letter, which I have no idea yet what they're going to say, but they did vote to make a subcommittee and work on it. So.
And that's all I had.
August 18th is for lawyers expert witness. That's a deadline.
Okay, thank you.
So Erica, does that conclude the staff report?
Yes, thank you.
Great. And then next on the agenda, I believe, is discussion of the annual ethics symposium. And I can start that off. I don't know if that's part of the agenda materials. I'm not sure if everyone's had a chance to look at the feedback received overall and for each panel, which it was overall positive feedback, but there are also things to, work on for future symposiums that we can talk about as well. One theme that I saw in a couple of the comments is just trying to make sure that we have diverse panels going forward. That seems to be one area for improvement. Also, as we all know, just getting some of the written materials ready ahead of time. I think they were delayed this year, so they weren't able to be shared with the attendees in advance. And there are a couple comments asking for additional written materials. I think overall, it seems like the audience found the panels very informative and helpful in addressing complex topics, and they appreciated them. But I'm gonna just pause and see if others have kind of feedback on things we can work on or things that went well.
Are we wedded to the virtual context forever? We love it. More people can see it. As a presenter, it's really weird. It's just nowhere near as interesting and interactive. But if we're getting a lot more viewership and if people like it better, that it is what it is.
It used to be held in person and webcasted as well. This is pre-COVID, obviously, but I don't know, going forward, that's kind of up to you guys.
Does the state bar have a view on it?
Not necessarily. So I think at a minimum, we would be looking at a hybrid going forward, just because I think that we have gotten significant more participants in the remote format. And I think that, frankly, people are getting kind of used to having remote MCLE at this point to a certain extent. That being said, we of course see the value of having the in-person for the presenters as well as for the audience. There's a lot more engagement in the question and answer section to a certain extent when it's done in person.
Right.
So I don't think there's necessarily anything that would prevent us from doing that in the future. And I think that if that's the committee's preference, that's something that could certainly occur. It would likely be, going forward, it would be out of the LA building that the symposium would occur in person. But that's certainly something that we can plan for next year. That's the prerogative of this group.
Okay.
I do have to say that the attendance has jumped significantly. When we did it in person with the webcasting, I think we topped off at like 175 or something. And now in the past few years, when we've done it remotely, we've gone over 500 attendees each time.
And I do know that, in the in-person before times, it was really ethics nerds, it was very selective for ethics nerds. So the discourse would get pretty intensely nuanced, but and so maybe we're bringing in a lot more members. Just the only thing is that Zoom presentations, it's always hard to tell if you are being interesting or it's time to move on because you can't see anyone, and it's just more of a challenge. But
I do want to point out, though, that part of it was also it's more cost effective. We're able to offer it for free when we offer it by Zoom. Then there's a question,
right.
we do in person. Do we charge those people? Because now, it's a little bit different. I mean, we can talk about it in the future. Maybe we offer it for free for everyone, whether in person or not. But oftentimes there's travel involved, whether it's speakers or,
Right.
committee members and that kind of stuff.
Okay.
Yeah, and on that note too, I can't remember. I know that on individual panel basis, we discussed whether to leave the chat on so people could ask questions, because I did see that as one of the feedbacks. I think people felt like they couldn't interact, right? The audience members. And I thought we had it on for, I don't know, did we have it on for all panels or just certain panels?
The way it works is there's it's chat versus Q&A. So the chat is disabled, and that's kind of a larger policy that the chat be disabled. What happens is the Q&A is enabled, and that allows for panelists and any staff support to see the questions and answers. And depending on the context, they can certainly be answered either via chat, and those answers can be publicly posted to all of the attendees, or they can be answered live, where the panelists would, read the question or restate the question and then answer those questions. It is certainly a different format, obviously, than in person where people are just asking it for everyone to see and such.
Yeah. So maybe we need to repeat that more throughout just the Q&A. I think we do it at the beginning and maybe some of the people didn't realize they had that option. But the other thing that I thought was effective just from my own perspective, I didn't see it so much, but I think it was during the AI panel where they had kind of a survey.
The polling.
What were you saying, Mimi?
Oh, they did polling was what it was. Yeah.
I always find that makes it a little bit more interactive. So if there's ways we can in the future, I think try to make it more interactive, even though it is remote, by doing something like that, I would recommend that. That seems very useful. But
some age discrimination in the commentary about the AI panel, referring to an older gentleman.
That's outrageous.
Older gentleman who was in the early stages of COVID at the time, but I also understood some of the comments on, just for future reference. I mean, with my panel, working with them remotely, I tried to steer them into each kind of having a topic to cover. And instead, they wanted to have a back and forth instead of each having a topic, which I like that style, but you still have to have someone who's prepared to take the lead, like on a particular sub-issue. And, they just didn't want to do that. So what they did was they gave me a series of questions to ask them. And so that's basically what it turned out. So I understand some of the commentary on that. I would have preferred to have them, I think they're all excellent and very knowledgeable, but it was incumbent on me as the moderator to get them to speak and draw out certain issues on the particular topics, which I agree was beyond my expertise is on AI issues. So even though I am an older gentleman, at least they use gentleman. But
That was polite of them.
yes.
I guess my
And
joke
on
about
the chat thing too, if memory serves me correct, we had that on once before and there were some fairly profane comments and
yeah.
I think that's why the chat's been turned off, if my memory is correct.
I have a colleague who serves on a hospital board, and somebody went to the trouble of hacking, like literally, like they tried to keep a secure Zoom, but somebody hacked in order to be obscene at a hospital board of trustees meeting. Like, how gratifying is that? What a weird. Anyhow, so I understand all the security precautions. So.
What I will say is I think so all of these discussions, if we wanted to host it hybrid next year, it's June now, but next April will be here before we know it. So I certainly think, these conversations should probably continue as far as, co-prac leadership and others, as far as starting to, really plan out what the committee wants it to look like next year. And, starting to get that plan to the extent you do want it to be a hybrid so that we can make sure that everything is in order.
Can I ask just one last question on this topic from the audience we did get? Do we have any sense of whether they're deeply steeped in ethics or just attorneys trying to get ethics credits? Because the latter is wonderful and we can kind of craft our presentation a little differently and not be in the weeds as much, Do we have any sense of that or any way to get a sense of that?
I mean, it's not on the survey, but I mean, just based on historical attendance, when it was in person and they were more, I guess, ethics geeks, people who are really into professional responsibility, our numbers would top off at 100, maybe 120 attendees, and I think what does help is by offering it for free, that we do have a broader audience that's interested in taking this course. So in the past, I can honestly say it tended to be a little bit more hardcore professional
Yeah.
ethics. I mean, it was, like people who were familiar already with the rules and existing case law and that kind of stuff. And so it tended to be tailored towards that group more. That's what kind of separated us from other types of MCLE programs that were offered at the state bar. This was like, if you really were interested in like just the most recent, developments, like that kind of stuff, that's where you came to the ethics symposium. So I guess it probably would have to be a balancing act going forward if we keep getting the same type of attendance that we have been getting.
Thanks. I didn't mean to derail the morning. I was just curious what we'll keep talking about it. Thank you.
And the one thing I just had a question, because I did not see as part of the agenda materials with just the reviews of the panels overall is, and we don't have to discuss this today, but was there also, do we have suggestions for like topics in the future? I thought that was one of the questions perhaps.
Yes. I didn't include it. I usually just wait until the following year when we start our initial talks about ethics symposium. And so I'll give you a list of all previously considered topics and then everything that was suggested by this year's attendees.
Okay, that sounds good. Okay, so before moving on to the next agenda item, I just wanted to see, does anyone else have comments about the symposium feedback we received? Okay, so hearing none, I'm going to move on to the next item on the agenda, which let me just refer to this is item B1, a discussion of 19-0003, the draft opinion on illegal contract provisions. And there aren't any associated agenda materials because this is really just an update. As I think you might recall from our last meeting, we decided to hold off on, we had made some revisions to this opinion, but we decided to hold off on any further revisions because there were proposed state bills as well as a proposed federal bill that could be relevant to some of the issues in the opinion. And I just wanted, so we we're going to monitor that a little bit before moving forward. And I think I reported this at the last meeting, but I think the proposed state bills are pretty much in short dead. I think they've been placed in the suspense file, so they're not likely going to move forward. So I don't think we should hold off for that reason. There is still the FTC docket, which is open and considering a ban on non-competes, which is relevant. And the latest that I have related to that FTC docket is that the comment period was extended, has now ended, and there were about 27,000 public comments submitted on that proposed ban on non-competes in employment law agreements. And as a result, it looks like the decision on that rule will not happen until April of 2024 is the anticipated date. So I think we have to consider that timing in terms of what we do with our draft ethics opinions on legal contract provisions, which does provide us, one example, the non-compete, although we aren't trying to opine on that issue of law. We're assuming for purposes of the opinion that the contract provision is illegal as a matter of law, and that there's no exception that would apply. But at the same time, I do think a lot of the basis for the opinion came from an organization representing employees, and that was the hypo provided by the initial request. And I think a lot of the comments we received have been relating to that particular aspect of the opinion and disagreement on that legal issue, which we really aren't trying to address through the ethics opinion. And we're trying to clarify that in some of the revisions. But so I think we just have to discuss, and this might be for the working group to talk about more after this meeting, whether we move forward with the opinion or should we hold off, which would be it's kind of a long period to wait until April to see what happens with this FTC rule, because then we have more of a concrete example that's just settled to provide as opposed to just an assumption. So any kind of thoughts? Since I'm not hearing any immediately, I think what makes the most sense is I think the working group then, if not, we'll just discuss this before our next meeting and determine if we want to move forward or not. And then we'll report back at the next meeting. If we decide to move forward, we'll have a revised opinion ready in advance to share. Okay, so let me just, next on the agenda I know is let me just pull up the item C2, which is the discussion of 210003, the ethics of in-house counsel. And Cassidy is going to present this item, but I'm not seeing, am I? Oh, there you are, Cassidy. Sorry, I didn't see you.
I'm here. Okay, thanks, Sarah. So I want to thank Dan and Justin for providing comments and reading this and trying to move this forward. And I made some revisions and kind of high level thoughts still about this opinion. So I don't know how we want to.
Is it just me? I'm having some trouble hearing, cutting in and out. Are other people hearing that?
Well, yes.
Yeah, looks like Cassidy's frozen now.
I think she may have froze.
I'm frozen. Oh, me now? Oh,
Cassie, it sometimes helps to turn off your camera if you want to try that. Just
Or maybe call in for the audio, just for the presentation. That might be easier.
Can you hear me now?
Yes,
Can you hear me now?
yes,
No.
we can hear you. Yes,
Oh, you can hear me?
yes,
I
yes.
switched internet. I can only hear Eleanor though. Everybody, you can hear me?
We can hear you.
Okay.
yeah.
All
Yes,
right.
we can hear you.
Great, thanks. Okay, so I don't know where I dropped off, but I just, one of the kind of questions I had as far as just kind of format is whether or not we should move the questions. The way I have the questions interspersed in the facts is I think somebody at some point had said it was somewhat confusing. So I was wondering if we should just move the questions down to the discussion. If anybody had any thoughts on that. The reason why I put the questions in interspersed with the facts was because chronologically it made sense, because it was, the attorney was considering going to company, from old company to new company, and then she had questions, and then questions arose as she was after she was employed. So does anybody have any thoughts about that? Otherwise I'll leave it, or if there's any other
This is
alternative.
Dan. I think it would be better to put the questions together. When I was looking through it, I did have that question. I see why you did it, and it made sense after I got through all of the questions. But I felt like it was a little bit confusing because the question arises before you know the facts related to it, or slightly after. I think it would be more clear if the facts were up front.
Okay, so yeah, maybe we can just reword the questions so it makes more sense, and just put it in the discussion.
Yeah,
I agree with that. As I was going through it, I was like, yeah, it does seem kind of disjointed, or jarring, I guess.
it made sense when I got through the entire section, but as I was going, I was sort of jumping back and forth. Yeah.
Okay. Okay, and then And then I just had a bunch of changes. Like minor changes. And so I thought maybe we could go through those, or how do you guys, this is my first time really going through in detail an opinion. So not exactly sure how you want to approach this, but I just thought I'd just go through each line that I had changes in. So like line 42. Oh, you're in, okay, wait, hold on. Hold on one second. Because I did the non-red line version. Where it says, so go up, so not line 42. Where it says the sellers changing. Hold on, I can't really see. Go down more a little. Go down more. Stop. Go down more. Okay, where it says line 50, where it says, i.e. the sellers under the proposed deal, I put, but before sellers put principal sellers, because the employees are also shareholders. So before sellers put principal sellers.
Why doesn't it show my face?
Joel, are you there?
The camera might be pointed at the ceiling, Joe.
Yeah, that's what it looks like.
That's what it looks like.
Okay.
Are we sure today's not Friday the 13th? It seems
Okay, so go down to, so it's not line 52. This is harder for me because I'm on the other one. All right, well, let's just go down to the section I have more, and I'll make these smaller changes myself. Go down to, keep going to this to under rule 1.9. Keep going. Where it's the same or substantially related section. Oh wait, sorry. Where it says 139 to 140, where it says cite, find supporting case or opinion. It's right there. You can put that's the Kirk versus First American Title Insurance Co. So KIRK. Put the Kirk case. I'm sorry, KIRK versus First American Title. And then just I can put in the full 801 to 802 is the page numbers. Okay, and then keep going down. Keep going down. So stop right here. No, keep going down, sorry. Okay, so where these sections are highlighted, and I think Justin and had raised a question about this. So the issue that I was kind of struggling with between the same or substantially related standard under rule 1.9 and the idea that it's, just having knowledge of the company's playbooks or having like the similar technologies is not does not necessarily meet that standard. Like, for example, Coke versus Pepsi, just because they're competitors, they're not, it's not the same or substantially related. So, but when we're talking about technologies, at what point does, a patent or technology become the same, a patent at a former, company and a patent at the new company, at what point do those become the same or substantially related? I would think it's when they are, suing each other for patent infringement. And so that that really falls under the material adversity analysis, because you're either directly suing them or considering directly suing them. But, other than that, and I don't know if we want to get into conflicts in the IP area, which is a whole complex analysis, but that's kind of what this is. So I'm trying to get more input on this issue, and whether if anybody has any thoughts or further thoughts on this.
This is Dan. I didn't think that they were redundant for that reason, because I thought that if it's something like a patent and there's a conflict, they would be litigating, and then you are in that other category. I think there are things in this category that are substantially related that aren't materially adverse. But I can't think of examples at the moment, but I think there would be.
Well, right. Well, like in the NASDAQ case, the quote here, all the patents at issue in this case relate to methods and systems of automation. Okay, so these are, basically similar technologies and patents that would be similar to our fact pattern potentially. That could be our fact pattern, that the patents at issue in this case relate to methods and systems. And so the only reason why the NASDAQ case, there was disqualification in the NASDAQ case, it was because it was the same or similar technology, but they were suing each other, or there was a patent infringement case, and so I guess the question is I don't know. I mean, maybe we change the facts, but the thing, and it kind of gets down to your other question, Dan, is that, the in-house lawyers are always going to move from company to company where there's similar products.
Right.
And so
there might also be like overlapping investors, and that's a level of, sort of playbook knowledge that is very likely to happen,
Right. And so I don't think there's a good answer here is my issue. And I keep going back to this 1.9 analysis, that, and the ABA opinion that does cover this, but it doesn't cover it very well, and it really does, have to do with the, in the IP world, and how we're going to give guidance to those lawyers that that move from company to company that have similar technologies, without it being a conflict issue.
Can I jump in for a second and just kind of set the stage for kind of where I was coming from in these two paragraphs, to maybe help understand where I'm seeing maybe kind of an ambiguity in the message that we're relaying in the current draft. So in this first paragraph, starting at line 229, we're saying, look, the old and new company, our competitors, they've got similar technologies, but that alone doesn't mean that we're going to have a substantially related matter that could result in disqualification. So that's kind of the message as I read it in that first paragraph. But then juxtaposed with us saying, just because there's these similarities, doesn't mean there's going to be disqualification. We then cite to a case which holds disqualification because of the similarity in technology. So I was seeing this kind of dissonance, this juxtaposition that creates an ambiguity between saying our facts with similar technologies and patents isn't enough for disqualification, and then citing a case which holds on that type of, in that type of situation, we would have disqualification. So it left me wondering what message we're trying to relay here.
Right. Yeah, I mean, and that's what I was getting at, is that, you know, at what point do technology so similar that they create a conflict, that they create a basis for disqualification? And I don't, you know, I think that needs, that needs to be addressed here, because I don't know if we say, you know, if they're somewhat similar, you know, like the Coke and Pepsi, like what is the test there? And so then we're getting into all of the IP conflict cases. And so, which is fine. I mean, maybe, you know, I can go back and find the distinction, you know, where if it's just a similar product versus a similar technology, where the patents are similar, you know, it's so similar that they would be, you know, arguably subject to infringement claims. But you know, I think that's a highly factual analysis. So it's hard to provide general guidance in an ethics opinion on it.
I thought, so I take Justin's point, but I sort of think that there is an ambiguity there, but I left those two paragraphs thinking it depends on the facts, right? So, and as you say, it may be, is it possible to cite another case or have some illustration of another authority where there was no,
right,
you know, they were close, but not directly, or not so much so, because I think the message there is that it depends on the specific facts of what you're doing, right?
And do you have any analysis of in-house roles in this context? I mean, the law firm scenario, I think, is a little bit easier because you're directly representing the entity in connection with, you know, specific facts of the case, whereas an in-house counsel has a much broader remit and is arguably a lot less involved. So what would constitute real representation and substantial? I don't know. I mean, the test seems like it should be a little different to me.
Yeah. Well,
Yeah, so-
I mean, and that's the thing, like, this is a lawyer who was, you know, who is in the labor and employment department and not directly related to the technology. And so the answer, you know, the bottom line answer there should be that this lawyer should be able to go to, you know, a potential competitor, because you know, their connection to the representation was not direct, you know, but that's handled in the you know, personal representation 1.9a analysis. So yeah, I mean, so I mean, the analysis under 1.9b really has to do with whether or not the lawyer had access to confidential information regarding, you know, the patents. But I think this paragraph assumes that there was some access, and then the question is well, are they substantially related? And then is there material adversity? But I don't know. I think that maybe I'm being too technical with the analysis, and it should be more of a flexible analysis, like, you know, the Kirk case talks about. So maybe this does need to be reworked a little bit more. What do you guys think?
Yeah, and to Eleanor's point, you know, if we're looking at maybe seeing how this plays out in the in-house world, and see, you know, if there's something that we can draw from cases in that regard that might help clarify what we're trying to do here, I would suggest starting with the Schlumberger case. Let me see, it's 859 F2D 512. It's a Seventh Circuit case, and it's in this patent in-house counsel world when you go from one competitor to another. And maybe that'll help us, you know, just as a starting point, looking at how that case played out. Maybe that'll help clarify what we're trying to do here. And maybe I'm missing it, but the facts I don't quite remember as precisely as I'd like. But if we're trying to say, look, there's this labor and employment lawyer, he's going to a new company, and just because that new company works on the same technologies doesn't mean that he should be disqualified. maybe, or, maybe that's a distinction here as opposed to a patent lawyer who works with the technologies day to day going to a competitor also to work on similar technologies, which is what happens in the Schlumberger case and a lot of these patent cases. So
Where there was disqualification in that case.
yes.
Yeah, I mean, so I think that's like the NASDAQ case where the lawyers were directly working on the patents and then moved over and, filed the patent infringement case against their former client, but it's not in-house. So let me, yeah. So maybe the Seventh Circuit case is more on point. Okay. Is there anything else on these?
Have we thought about, and forgive me if I missed this, but have we thought about whether or not in some of the cases, some jurisdictions, and I haven't looked at this in a while, they're kind of like a de facto conflict if you had exposure. Some of them establish a presumption of knowledge, some don't. Do you know if there's a difference between, if any of the cases have a difference between law firms and in-house counsel in this context?
Well, the Kirk case is government lawyer going into private practice, and that's the case that talks about, there's no, it's not automatic vicarious disqualification of the law firm. So it's, more of the flexible analysis. So and it has to do with the screening issues, which I think, screening as a whole, and Dan raises this question, is how do you screen in the in-house context, where the lawyer is basically the entire legal department, and then is involved in, most decisions of the company. So I don't,
And that can happen in a law firm environment too, right? You can have an in-house legal that's large where screening might be feasible, and you can have a law firm. That doesn't strike me as different in law firms. You have smaller law firms where screening is really not feasible, larger ones where it is.
Yeah.
That's true. One thing that came to mind was like the general counsel function to certify compliance with different things, or to provide audit letters and things like that, where you have to have a knowledge of all the matters, things like that. Right.
Well, yeah, I mean, I didn't even think about audit letters, but yeah, I mean, that's, so when we get down to the screening section, the suggestion I have is that, the problem with disqualification in the in-house context is it would mean that the lawyer would have to leave, that you can't have, it's unworkable. So, you can't disqualify a law firm, a company's legal department, that doesn't make any sense. But getting back to, so I think that the disqualification analysis where there's, automatic vicarious disqualification can't apply in an in-house setting. And there has to be a flexible approach.
That makes sense. There might be some analysis that could be useful. I haven't seen it in a while. I can look for it if it's helpful, but I think there is a case out there imputing liability or imputing knowledge to a company's entire in-house counsel in the context of a secondment.
I'm sorry, say that again. In the context
of a secondment, where an imputation went both ways.
Okay.
And I think they delve through some of these issues with respect to like, what's the role of the counsel, whether or not they could screen, etc. I don't think it's a California case, but.
Okay. Yeah, I know there's cases out there that talk about in-house, disqualification, and there's not many, I don't think, but I don't know. I don't think when I originally started this, I didn't want to really get into the disqualification element of the conflicts analysis, I mean, I know that it's kind of necessary, but it's not, it's more of it's that, we're not talking about really like litigation at this point. I mean, in the fact pattern. Okay.
Cassidy, I just had two additional comments on the issue we've been discussing. One is just relating to this, the case you cited here. I view this also as turning on the other element, which is the adversity, the material adversity element. In that case, the lawyer had represented previously the company in connection with the patents, and then was arguing the patents were invalid in the subsequent matter. So it was materially adverse.
Right.
And so we're using this as an example, and I think they address both issues, but so I think, I'm not sure if it belongs here, or perhaps you could consider it in the next section, the citation to this case, if it's causing confusion. And then just one other issue, because I know we were talking about looking at this in terms of in-house counsel, and I was just curious, as you were talking, I just pulled up the Free Vogel on conflicts, just to see if there was anything, because it's pretty exhaustive. And I did just want to reference one case site, and it doesn't look like it's a published case, just so maybe you could look into it, because I just located it, which deals with an in-house counsel who was a former patent counsel. I know, so in case it's might have any useful analysis, I don't know from this very quick summary, but it's a Southern District of Indiana case, and the case is, unfortunately, I don't have it. Maybe it's not the greatest because it's not it doesn't look like it's published. It's 2000 U.S. District Lexus 16087. I don't know if you use Lexus. If not, I can try to pull the case because we have Lexus.
No, I have Lexus.
Okay.
Yeah, I haven't. I know I looked at the Free Vogel stuff when I started this. I haven't looked at it in a while, so I'll go back and look at that. Okay. Yeah, I mean, okay, so I think I haven't felt comfortable with this section at all, and I feel like it just needs to be reworked a bit more. I guess I'm afraid of it becoming too unwieldy and getting into just a whole analysis of IP conflict, but I think it's necessary, and I just need to figure out how to kind of distill it and make it make sense. Okay, so are there any other, let's move down to material adversity. Let me see what I have in there.
I mean, as you get into the in-house world, are you dealing with the issue of imputation as well?
You mean, yeah, I mean, imputation to the legal department.
To the entire department. That's what you're worried about, right, with the law? Like,
well,
I just want to,
yeah,
is there
I mean,
a section on it that,
I mean, that's what vicarious disqualification is, right? So, but there's, but the tainted lawyer is the GC. And so, yeah, I mean, so the question is then, okay, so she's the tainted lawyer, and so can she be screened off of there's only two others in this legal department that, under the facts. So it gets to the question of, can she be properly screened or adequately screened where, there's just two other lawyers in the legal department, it's like the small firm issue. So,
I think I was driving toward timing. Sorry, I didn't articulate that well, but
those timing, like the screen is
right.
is implemented promptly.
Because it seems, I mean, that seems different in the context of in-house work, right? Where you're
Right, like when you get hired and then when are you gonna screen everything? Right,
Exactly.
that's a good point. Yeah, yeah, I mean, it doesn't really fit, you know, this analysis, it's very difficult to fit it into the in-house context without it, you know, making it an impossible move, you know, and so, uh, yeah, and so I don't know the answer to that. I don't know, you know, if the rules must be relaxed, you know, more than, you know, law firm to law firm moves, or you know, are we creating a new, you know, a new application of the rules, you know? So I don't, yeah, I don't know about, does anybody have any suggestions about how you can screen in a small in-house legal department? It's, you know, and, you know, well, can the answer be, well, you just can't take this job, you know? I mean, unless they're direct competitors or they have, you know, directly competing patents, I guess. Yeah, I mean, the answer would need to, you know, you should be able to move from company to company, and that's what happens. So does anybody have any comments about that?
I mean, you definitely have competing policy issues here. There are a lot of cases talking about the effectiveness of screens that would probably help guide this. And I think some of them are based on, you know, access to records and things that could be addressed with appropriate controls in place.
Yeah.
Especially if people are in a remote work environment, and, like, you know, so I think that the factors might be different than they were when those cases were written. But there's a ton of cases out there on effectiveness of screens that I think would inform the analysis or tell you maybe how to do it.
And well, right, but it gets back to, how do you screen the entire employment, you know? So,
Or do you need to? I mean, yeah, that seems like a fact dependent issue though, right? When would you need to screen the entire employment from, say, only when they're adverse? You'd have to prevent them from doing something that's adverse to the former employer. Right?
well, I don't think it's screening, you know, the employer from the rest of the legal department. I think that if we're talking about, well, yeah, I mean, I would say, like, it gets back to when you're talking about a particular, say, patent, you know, so that would be a, you know, particular matter, I guess. Then, and you can't effectively screen the GC, then you have to refer it out to outside counsel.
Right. It's kind of like getting conflicts counsel.
Yeah. And so, you know, but then the next question is who is that counsel going to report to, you know?
Maybe your number two, or
right, the CFO or the, yeah, not, but the GC could not be a part of it.
Right.
And I still think that's problematic because then you have no in-house, well, yeah, I mean, I guess, you know, as a practical matter, then the CEO cannot rely on their in-house counsel to, you know, inform their legal decisions. You know, they would have to rely solely on their outside counsel, which I guess is the point, is that, you know, so I think, and that's, I think in the screening section, that's what I intended to say, is that, you know, there may be situations where you just can't, you can't have an effective screen and there is a conflict, and but that doesn't necessarily mean that the GC can't be employed or has to, you know, leave the company, but that the matter should be referred out to independent counsel or outside counsel. Does that make sense?
Well, that could be the case whether or not there's an effective screen, right?
Well, it can be part of the screening process.
Yeah, exactly.
Yeah. Yeah, I mean, it falls within, I guess, the screening analysis, but it's just, it won't, yeah, I mean, I guess it's not,
I think that's right. I think that's the way to look at it, is that's the screen.
Right. Okay. Okay, is there anything more on the 1.9 analysis? Okay, let's just go down. I think I have a better handle on the 1.8.1 and 1.7 analysis. So you can scroll down. Oh, wait, scroll up. So Dan, yeah, this comment about, oh, okay, this is kind of what we're talking about. But Dan, you also had a comment about, NDAs, like say that they hire somebody from old company, another employee that had an NDA, and she wants to challenge the NDA that she probably wrote herself while it.
Yeah, it's just trying to think of instances that would be direct conflicts. That would be one if you're employment lawyer.
Yeah, so I think that's a good example where, taking it out of the patent, the technology world, and, within the labor and employment, there still could be a conflict. And if that happens, then that would be a situation where there could be a screening, where she couldn't do that, right? They wanted to
clearly, yeah.
But somebody else in the legal department probably could, I suppose, or outside counsel.
Yeah, I think so. I think it'd be awkward, but they could.
Right. And I mean, that's the thing. These things happen all the time, and without any sort of lawsuit or, so. Okay, so the 1.8.1, so you can scroll down, sorry. So I just kind of cleaned it up a bit more. I'm trying to think. I don't think I had any major changes other than what's here. Did anybody have any comments or suggestions about this section or find it problematic at all? No, okay. Let's see. Yeah, it keeps going. I just want to see. Yeah, I reduced some of the block quotes, and I can probably do that a little bit more on some of these. Okay, go down. Okay, wait. Let's see. I think that's Sarah's comment. Oh, so yeah, I mean, this is a comment that we've had in here for a while, but I kind of have been ignoring it. I'm sorry, Sarah. But you had some, can you scroll down so I can see the highlighted section? The facts don't address the amount of value of stocked options, which I believe is a relevant factor in evaluating whether there is a material limitation conflict. So do you mean, the value of her stock options as in relation to her total assets, or do you remember what you meant by that? I know this is a very old comment.
Yeah, I was just wondering what, I thought it might be relevant what the value were, because it was minimal. It doesn't seem like it would necessarily give rise to a material limitation conflict.
Right, like millions of dollars versus, $10,000 or something like that. And I think it is relative to her total, like basically it's, how much interest she has in this asset, and how it'll dictate her decisions. Okay, so maybe we can throw in some more facts about, like this is her primary retirement vehicle or something like that. you know, what she, like her primary, this is her primary asset or something like that.
Yeah, and I don't know the best way to do it. I guess the other option is to just reference that this might be a relevant factor if we don't want to directly, if we don't want to include additional facts.
Okay.
Yeah.
Yeah, okay. Okay. Okay, and yeah, I'll make that change, Dan. And I think that's it. The other kind of overall question I had, and I know this is kind of political, but I have such a hard time reading the and writing the opinion when it's, you know, they versus he or she, you know, when we're talking about, you know, the gender issues. Do we have a policy on that? Do we have to, you know, because I changed the lawyer to her throughout, but there is still reference to, you know, they as a pronoun instead of he or she, or you know, does anybody else find that confusing? Is it just me? And do we have a policy on that?
Can we just use lawyer?
Yeah, I mean, you know, that's what I tried to do throughout, and then I still caught where I had they, but I was just curious. I'm sorry.
We're not supposed to assign any gender. It's they, them.
It's so hard. I know.
We'll go through it and we'll fix it. Don't worry about it.
Okay, I know.
It's just a style guide that we need to follow. But staff can take that, Cassidy, if that's something that you need us to assist with. That's not something that you have to.
Okay. I know. I hate saying this out loud, but it's when you're dealing with like complex concepts, it's hard to. So it's just, you know, the easiest read is the best, you know, it's just hard to kind of adjust to it. But yeah, I know, I think we need to get used to it. Okay, so that's all I have. I will go back and rework the 1.9 analysis again. And I think, and thank you for, you know, more guidance on that. I think I need to find more in-house counsel conflicts cases. It's kind of my bottom line here. And hopefully that'll be more helpful.
And so what are we thinking about in terms of next steps for the next draft? Do you think the next draft will be one that we might, so I think you've made great progress, but do you think the next one might be one we could consider at the next meeting?
So I won't be at the next meeting.
Oh, you won't be? Okay, so I forgot.
Yeah, so yeah, my thought is I'm actually going to be in Europe, and I will be working for part of it. So I'm going to have a chunk of time to really sit down and focus on this, I think, while I'm there. So my hope is that I'll be able to do that. I mean, so I'm literally going to be in Europe for an entire month. 2 weeks of that month, I'm going to be working. So,
okay.
Yeah. So no, I'm not like, you know, taking time off of my vacation. I'm definitely going to be working. So, but I should have a chunk of time during that 2 weeks to work on this. So, so yeah, my plan is to circulate at some point during that time, and then by the August meeting, it should be final for public comment, hopefully.
That sounds great. And I was also, yeah, I think that works well. I was also wondering if, like, I know some of this stuff, like there's some additional research that you're going to look into. Is that something, Erica, you might be thinking this as well? Is that something that staff could help with? I understood that maybe we have an additional staff member that might be joining.
Yes. I was actually going to save that for kind of the end of the meeting, but this is a great opportunity to talk about it now. So yes, we do have a staff, a new attorney who has started in the Office of Professional Conduct. That individual can certainly help with, frankly, anyone's opinion that needs some assistance, be it research, drafting, etc. So to the extent, you know, Cassidy or others working on other opinions need someone to kind of just, you know, create some forward momentum on an opinion where you're either stuck or need some research or just don't have the capacity right now, but you want to keep the opinion moving forward, which, Sarah, I think is something you're going to talk about a bit later as well, just whether or not we want to move forward with some of these opinions. certainly we can do that. So you can, send me an email on, what issue you want them to look into, or just, a more general email, can someone please work on this opinion? And we can get that assigned out. And then similarly, from a more administrative perspective, to the extent you want your working groups to be meeting more frequently, as we all know, scheduling meetings can sometimes be the hardest part of a meeting. So we can certainly work on helping to coordinate some of those meetings. Either, we can attend or we can not attend, depending on your preference, just to kind of help with that as well.
Yeah, that would be great, Erica. Yeah. Some helping research would be wonderful.
Yeah, I appreciate that. And I just wanted to mention it because I know that I think this opinion is far enough along that I'm hoping that maybe by our August meeting, when we discuss it, maybe we can vote on it. Because I think you've made great progress in the working group. So
I'll just quickly say, I don't think we have an August meeting. So it's been floated a couple times.
Oh.
We have a July 28th meeting and a September 15th meeting. At least that's what it looks like on our calendars right now. So, if the prerogative COPRAC is to have an August meeting, we can certainly talk about that, but I just don't want to create any confusion amongst the committee members.
No, I guess I overlooked that. For some reason, I was thinking we had in August. So sorry.
Yeah, we usually have a longer gap, at least traditionally, between in the summer at some point. And so it looks like that's between the July 28th and September 15th meeting, but same thing applies. So we could certainly, move it up or just have more ready to go for September.
Well, if it's right. Yeah, I mean, I suppose I can, because I won't be back until August 2nd. But I can, hand it off to Dan to present and have it finalized. Dan, but I can work on it. I can maybe get it finalized. Yeah. And if we think that it's ready to go for the July 28th opinion, great. If not, then it can wait till September if everybody's okay with that.
Okay, great. Sorry, I think I was just debating me. So just so everyone knows, I think we're gonna likely conclude early today. So I was just looking at timing and trying to figure out what to move on to next. I think we really have just 2 more items on our agenda, one of which will be very brief at the end. So the next item on the agenda is discussion of AI, and that is F1, and that's the discussion of the board's request to explore the use and regulation of AI, and Brandon's going to take the lead on that. But before we do that, I also just wanted to see, I think since that's the last item, and there might be one other that maybe we'll just, I don't know how long do you have an idea of how long that presentation will take, Brandon?
It'll be pretty quick.
Okay.
We had one meeting, and none of us are computer scientists, so we're not going to take too much time.
So I think we're going to likely end by noon anyways. I was going to wonder if we should take a break or not, but I think since we're likely going to end soon, let's just keep on going unless if anyone feels like they need a break. Okay. Thanks, Brandon.
Should I get started now, or?
Yeah, I think you should go ahead if you want to kind of talk about the first meeting with the working group.
Yes.
And next steps, that would be great.
Yeah, so we had an initial meeting, and one of the things we're trying to do is figure out just the framework of our approach. Eleanor and I both had a starting position that we have a robust and well-developed set of ethical principles that so far we do not see as necessarily challenged by AI. AI is a new development, but in our view, it looks like it falls within the ethical framework we already have. So maybe something along the lines of an update or best practices, not an opinion, might be in order to remind practitioners of their ethical obligations and how those might interface with AI. But we're trying to do it humbly. We want to learn more about how AI is actually used in the law so we can see if, we just want to keep an open mind and see if there is a novel ethical issue here, as opposed to just yet another new technology that practitioners have to use within the existing ethical standards. And that'll guide our approach to whether a really ethics-based opinion or something might be warranted, or whether this is just sort of like an alert we want to give practitioners to be aware of. And we brainstormed a bit about some things that might be unique to AI, unique ethical issues, but we think we need to learn a lot more. Because honestly, I'm just at the very outset of learning how this stuff can be used. And the high profile cases we've seen, you know, the airline litigation, it reeks of such, you know, shocking negligence that it's not really a complex ethical issue. But that's where we started, and we're going to reach out to some experts in computer learning and learn more about how law firms are actually using this today. And then we'll come up with the best, I guess I'm searching for the word, the best vehicle, whether it's, you know, on one end of the spectrum is a formal opinion, and on the other end of the spectrum would just be sort of an alert or best practices, you know, so, an article, the rules of professional conduct don't cease to exist when you play with a computer engine, you know, things like that. We're trying to learn a lot so that we are not just pontificating blindly. And Erica, you can maybe tell them about that thought exchange. You know, there's going to be Erica, you can explain what the state bar is going to do with the licensees, asking them about their thoughts.
Sure. Yeah, thank you for teeing that up, Brandon. So yesterday, the working group members kind of got a preview, and I'll share my screen just briefly so you can see what it looks like. But the state bar is going to be soliciting thoughts from all of its licensees to the extent that they're willing to share them. So, you know, this committee is very familiar with the traditional public comment process where something is issued and licensees or whoever wants to give public comment reacts to that and gives public comment on a particular thing, be it an opinion, be it the rules, etc. We're trying to kind of switch it up a little bit here, and instead of giving them something to give comment on, we're soliciting comments kind of before there's anything for them to give comment on with a more general question. And the working group will be, you know, considering whether or not they want to shape that question or staff, and it's going to go out to all licensees to solicit responses. So the working group had a chance to participate in this yesterday, and I'll just kind of share the results. And this will likely go out in the next few weeks. And basically what it is you participate in answering some survey questions and just kind of a more general, larger, big picture question, so which is open-ended. So that big picture question that the working group answered yesterday, hopefully you can see on the screen, is, you know, what are the most important perspectives and issues for us to consider as we explore the use of and possible regulation of attorney use of generative AI? And so yesterday at the working group, there were 6 participants, and they gave 11 thoughts on this. So you can just free form type in, you know, client confidentiality is the most important issue, you know, whatever you want to put. And this will be what a licensee can do, is they can put any text in here they want to, and they'll say what they think is important and essentially maybe why they think it's important. And so that's kind of the initial step. And then what happens is people move forward in the process and they're able to rank some of these things as important or unimportant. So they're able to, you know, click through them. I can show you here. So these were the top thoughts, and rank them and move them up or down in that process. And so, you know, so the responses to that open-ended question were what was provided here. So just to stick with the theme, protecting confidential client information, that was ranked as the second most important thing of all of the thoughts that were generated yesterday. So we're going to be sending this out to licensees, like I said, in advance of any type of, you know, opinion or article or whatever methodology COPRAC intends to provide guidance to licensees on generative AI, to kind of, you know, see, one, what licensees think is the most important, and also to see if there's anything that COPRAC may not be thinking of that maybe somebody who's working in this AI, you know, in this space may have more information to provide to kind of inform COPRAC. From a staff perspective, what I think is really cool about this is it's a report that comes up right away. So this platform, Thought Exchange, they're using OpenAI themselves to generate these types of things. So we did this Thought Exchange yesterday, and the results were immediately available. So it's not, you know, scouring through, you know, hundreds of public comments where you are trying to identify the most common themes and what is most relevant. it's doing that for you, which is really interesting as well. So we'll have, this will be rolled out in July, and we expect to be able to bring this back to the full committee at the July 28th meeting.
So for anyone who really delights in irony, this SharePoint Thought Exchange program has a machine learning aspect, and I personally adore the idea of having a machine learning telling us and guiding our thoughts on the regulation of machine learning. So it's pretty cool.
I'll just say, as it relates to the upcoming July meeting, so Brandon briefly spoke on this a little bit. A lot of the conversation yesterday, or not a lot, but some of the conversation was, we don't necessarily know everything there is to know about generative AI. And so to the extent we had talked about this, I think is a little bit of a preview that we want to have, experts of some kind come in and kind of better educate the COPRAC on what, generative AI is, or how law firms and lawyers are using it. Be it from some of these, I know Lexis has a new AI platform, Westlaw does, there's Counsel, there's so many different ones that are coming out right now. So to the extent we want experts to come in and educate us, that's kind of what we're starting to set up for July to a certain extent. And so to the extent you have people in mind that you may want to participate in that, staff is happy to coordinate that and work on that. And so just let me know, and we can make that, do our best to make that happen for the July 28th meeting.
So I have just a question about the working group limitations, because it occurs to me that it's suboptimal for a couple members of this committee to get a bit educated on AI, and then to try to explain that to the full committee. Is it possible for other committee members who may be interested or available on the days of the working group meetings to attend, to listen, or is that going to break our rules?
So it would depend on how many is the right answer here. So we need to be under a quorum.
Okay.
If for some, we could certainly have a noticed meeting, right, where we're educating COPRAC members on generative AI. There's nothing that would prohibit us from having another meeting. All that's required is 10 days notice and it being publicly posted. So
Okay.
if that's something that COPRAC wants to do before July 28th, we can certainly try and make that happen. Our June meeting and our July meeting are very close. So it may be that at least that July is the soonest we do that, but going forward after July, that's certainly something that we could do as well. Depending, again, staff could solicit how many people could actually attend that date. And if we need, because of there's 10, for example, that want to attend, we would be able to publicly notice it.
Okay, I just want to avoid the telephone mutations of me ever trying to explain what I might possibly learn about generative AI to other lawyers. But I'll do my best.
That sounds great. Does anyone else from the working group have anything to share on that AI or?
I don't have much in the way of substance to add, except that I did follow up with some colleagues and have a list of names of folks our team considers to be thought leaders in the space that I have an email drafted and I'll share with the working group.
Great.
That's great. Okay, so it sounds like we'll have a good discussion for our next meeting based on some of the feedback we get. The final item that I just wanted to briefly discuss, and I think it might be helpful, if Angela, are you able to just put on the screen kind of the assignment agenda for this meeting?
The assignment, yes.
Because I just wanted to go over, because there's a bunch of opinions that have just kind of nothing, and I understand people are busy, nothing's really happened on them, but I just want to see if we can at least agree if we're gonna, if the members of that working group are here. I know we're missing some members, but if we know we're going to move forward or not, because if we're not, then I think there are a lot of other opinions on kind of the list of opinions to consider that I don't want to take on more without making progress on these other ones. I'm just trying to balance priorities, and I just wanted to briefly go over it. And I see Erica, your hand raised, so I'll pause before I get into that.
Yeah, I'll just say that I wasn't sure if we were going to have a full discussion on this, but as at our next July meeting as well. So, we heard from some of you at our May meeting about the benefit of having on the new ethics opinions, kind of an advice memo on whether or not we think they should be moved forward. So based on, existing either mandatory or persuasive authorities, and if there's a TOPRAC or other local bar or other state bar opinion on this, be it from another jurisdiction. And so staff has been working on some of those. And so those, when we do go back to having meetings on new opinion topics, those will be prepared and distributed as well in advance of those.
Okay, that sounds great. So this first one we addressed at the meeting, and this one, I don't think this is an issue for the opinions that have gone out for public comment, because we're obviously going to be pursuing them. But just so, because I kind of have lost track given some of the delay. This client file release and retention duty, this has gone out for public comment. And could someone update us on the status of this? Because I don't know if this is entirely accurate this summer, revised opinion in accordance with discussion at the October meeting. Is that still, I just wanted to, if someone could update on the actual status of this, what's happened on this draft opinion. Just want to make sure.
Well, Hunter is, I don't think Hunter's here, but he had sent me an email a couple weeks ago that he was going to have some additional edits to circulate, but I don't think that happened. Maybe he got tied up with something. So I think that's kind of where we are, is he had planned to have some additional edits that he was going to circulate to kind of the working group or whatever we're called these days, and then have it for discussion. I can follow up with him because he's not here, and just check and see if maybe we can get that for the July meeting.
And then this, because I think the ones that have already gone out for public comment, we should try to prioritize. And then the conversion clause one, I think, is a public comment period still open on that one?
No. So the conversion clause, we got public comment. We've talked about it a little bit, and then the working group has. So, we have a view that we were trying to persuade the full committee on, and we are trying to put together authorities to see if it's persuasive to the full committee. And Joel was working on that a bunch already, but we're going to need some more time to meet and work on that and then present that to the committee. So it's still being worked on. I don't know. We'll see what kind of progress the full committee can make with it or not.
Yeah, and I forgot about that discussion. Now you're fresh. Yeah, I remember talking about that now, so that makes sense.
No, but I gave the working group a rough draft a few days ago, and definitely July meeting.
Okay, that sounds great. Okay, so this next set of ones are ones that haven't gone out for public comment. And we talked about the ethics of in-house counsel model already, and I know that Bill has worked on the cryptocurrency, and it sounds like that might be ready for our next meeting as well. And one of the attorney as expert witness one is circulating for public comment. So I don't know if this, I'm not sure if this is accurate, this assignment agenda. If you could scroll up a little bit, I just had a quick question about the
expert one. That's a different one.
Oh, you're right, Cassidy. Sorry. So the flat fees and termination one, Ken, what's the status of that? I think you're still on.
Yeah, I've been, the pandemic and postponed trials have caught up with me.
Okay.
So I've had a number of trials backed up. I've managed to resolve several of them. So I hope to have, my plan is to have an updated draft of that for the next meeting.
Okay, and I don't think I need to go over each of these individually. I just wanted, I was just wondering, because some of them, as we go down, they've been delayed many meetings, and I understand everyone gets busy, and so, but I'm just wondering if we've made progress, if there's anything that, as Erica said, that staff could do to help kind of schedule a meeting, or if there's something that needs to be researched so that we can try to move them forward, that would be helpful. And on the same, if there's any of these opinions that you feel that you've considered and just it doesn't make sense to move forward based on the preliminary research or outline, that would be helpful to know soon, because there are other opinions that I think, requests that we've received that raise issues, and we want to be able to address everything in a timely fashion. So if there's something on here like that we just don't feel are as important as some of the newer issues, like updating previous opinions, for instance, that's kind of on the end of this assignment agenda. If you could try to email Brandon and I before the next meeting, and alternatively, if you feel that you just need some help moving forward, that might be something that staff could help with, a discrete research issue or an outline. So I just wanted to, because this meeting, because we are going to end early, because just unfortunately, we didn't have enough assignments turned in on time. And I understand that's partly because of everyone's schedule, but it might also be because we just don't feel like these opinions warrant moving forward, and it's better to know that earlier. So I just wanted to raise that. And so if there's anyone that knows that's here on one of these opinions that feel that it's just not something that we should move forward with, you can raise that now. Otherwise, just email us before the next meeting. So I think, yeah.
Oh, can I just add briefly, if any of these two, if you think at this point they're better suited not for an opinion, but like an article or something like that, that's certainly something that staff could help you with too, converting it out of an opinion format to kind of make it into more of an article as well.
Okay.
Yeah, I missed this. They're delivering a refrigerator here. I got all kinds of technical issues, but and it's not an AI refrigerator either. But on the written fee agreement one, I will have a draft also by the July meeting. So that one got put on my back burner because of my surgery, but now it's going to get done.
Okay, that sounds great. And were there any other issues members wanted to discuss for this meeting?
On the determination of reasonable fee one, I thought that was gonna, because that was updated by the fee arb committee not too long ago. I don't remember why we were going to be updating that one, because I'm not sure there's anything really new to add.
This is Elizabeth. I had proposed updating it to incorporate the analysis that came out of the Shepard-Mullen Supreme Court decision on where a contract is voided for violations of the rules and how that affects. I'm not aware if I'm looking at the one, if the version I've been looking at, I've been working on a draft that I haven't circulated to, it hasn't been ready to circulate to the drafting team yet. But I'm not sure, I'm gonna have to look and see if there's some amendment that I'm not aware of that might impact what I'm doing, because what I've been working on.
I think Shepard-Mullen's in that one. I'm just calling up the advisories now.
Okay, I'll double check, and if they've covered it, then I'll let everybody know, and we would be able to remove that, and I'll stop doing unnecessary work.
Well, actually, Elizabeth, having just reviewed that advisory, I think it still works as a standalone advisory, but it wouldn't just have an advisory focusing on, is there a different standard of care or different standard of determining the quantum merit recovery under factors which are set forth in the second half of the Shepard-Mullen decision that talks about quantum merit, because they use terms like provided that the conduct is not egregious or the breach of duty is not egregious. And there's some other things in there, and it may be helpful just to focus in on, have a separate Shepard standalone one rather than try and redo the whole reasonable value one.
That's a good idea. That's a great idea. I'll think about that in that context, because I mean the other one is quite a lengthy document, and it might be a lot more efficient to do it that way. But I think that is important, having that in the advisory somewhere about this, the segment of the opinion that you're talking about, where it kind of puts the burden on the lawyer to establish that the breach of the rule or duty wasn't egregious. Right?
Yeah, well, to the extent that after looking at Shepard-Mullen, if it doesn't change how you go about a reasonable fee, then the fix is just simply to say, and it works under Shepard-Mullen. On the other hand, if we think Shepherd Mullen creates a slightly different standard that arbitrators are going to have to look at when they're confronted with it, then I think it goes better as a separate advisory on Shepherd Mullen. That's my thinking.
Yeah, I was just looking at the advisories. I think I was mistaken because I know we updated a number of them and Shepherd Mullen was addressed in some of those updates, but I'm not seeing it in the reasonable fee advisory, and it indicates that was updated in 2015, so that would be pre-Shepherd Mullen. So I think you're right. It's not addressed in there. So.
And I mean, just
Okay,
practically
I'm gonna go
speaking,
take care of my refrigerator. Goodbye, all.
I think practically speaking, it would be really helpful to have that. I and my partner were trial counsel after the remand, and we represented JM after the remand. And in that matter, and in 2 subsequent arbitrations that I've had, this issue came up where, one side is advocating that the lawyer has the burden to establish this breach wasn't willful or egregious, and how does that impact the burden of proof and the shifting and the analysis and everything. And since there's not a lot out there on that since Shepherd Mullen, I think this would be really helpful.
Yeah, it's addressed. I know Shepherd was addressed in the handling of legal malpractice and professional misconduct advisory. And I don't remember whether we got into that in the voiding of fee agreements advisory or not. I can double check on that. I know for certain it's addressed in 2012-03, the handling legal malpractice ones. But yeah, I'm happy to work with you on that.
Great, thank you.
That sounds good. And Ken, are you already on that working group or should we add you?
Yeah, he is.
I think I am, yeah.
Okay, great. Okay.
But now I'm on it mentally.
Gotcha. All right, well, that sounds good. It looks like we'll have a lot to discuss at our July meeting. So I think we should adjourn this meeting unless there's any other issues I've overlooked. Brandon, others, anything else? Okay.
Thank you all. Thanks, Sarah.
All right, thanks everyone. Enjoy the weekend.
Thanks, Sarah. Have a nice weekend.
You too. Bye.
Bye.